If the idea of department versus citizen is there in your head, then there is no question of demystifying anything. You will remain a feudal lord, you will be the boss, and they will be the recipients of your justice, and whatever they receive, they will keep on going, I don't know, wherever it takes them up to Supreme Court, and things will keep going round and round. Somewhere you will have to accept that we are all creatures of law. This is the first point to demystify adjudication, because you are at that time not executive but a judicial person, quasi judicial. I mean, as an administrator, you belong to the executive side, but as a adjudicator, you have to show elements, or you have to show behavior, or you have to show the traits of being a judge. A fair judge is a person who hears. Now that brings us to lots of nuts and bolts of this whole demystifying adjudication. The first and foremost being that should we be transparent with the taxpayer that something is happening against you. If there is offence case, it may lead to some raid, it may lead to search, it may lead to summons, interrogation, etc. So he knows that something is happening. No, but there are classification cases, there are valuation cases, there are other cases, audit. Now, there is no secrecy in all these proceedings. That is why the pre-show cause notice consultation. So you call him and tell, this is our view. This is what the department is saying. He will say, give me a few days time. I will also consult. I am not expert. My core business is manufacturing, let us say this mic, manufacturing something else. But you are asking me to defend myself about tax, which is a specialized area. Let me consult. I will get back to you. He will come back and say, no, sir, whatever you are contending is wrong. All over India, this is the classification which is happening. These are contemporary values of imports. So my import should be allowed. My valuation should be allowed. My classification should be allowed. These people are enjoying the benefit of notification in a similar circumstance. So you cannot deny me that. So he will come up with it. At that time, if he is right, how many of us close it? How many of us say, yes, I accept, this was our contention, this is his contention, and I accept this contention as it is justified by so many sources, case laws, or things like that. How much of litigation gets solved, gets abated? But do we do it? We are on that us versus them syndrome. So no. Anyway, let me give a show cause notice and see. So it leads to a show cause notice. Now the show cause notice again is supposed to be one of the very, very beautiful documents in a litigation. It has to sum up. It has to sum up whatever you are contending, and also say what the other person is saying. It should not be a one-side issue. If it has taken only one-sided views, then the show cause notice is bound to end up as one-sided. Therefore I confirm. Therefore I do this. But is that the idea of show cause notice? Is that the idea of any show cause notice? The show cause notice is putting a person to notice that this is what are the facts which has come out. You please tell as to why we should not proceed with a penalty, proceed with a confirmation of demand, proceed with. Then he comes out with a reply. But if something has happened before issuing a show cause notice, it can stop there. In offence cases, of course, yes. Now coming to offence cases. In offence cases, invariably you form an opinion in your head that this man is a person who has evaded duty. He should be punished. In your mind, you are already punished. You have done everything. It is only a process that is going to happen. And what do? You put all the statements that you have recorded in a manner. Many of it is uncorroborated. Relied upon documents are such that only what is useful to you keep. You don't look into unrelied upon documents. You don't give it back to him. Then what happens? It gets confirmed. And then when it goes up, as he was telling, in the court, legal nuances are checked very, very seriously. And when legal nuances are checked, then our orders collapse. Instead, it is better that when we are giving a show cause notice, we really take voluntary statements. How many of us call it a voluntary statement, but is it really a voluntary statement? If suppose a person goes out and retracts it, sends a registered post next day saying, I am retracting this voluntary statement. That means somebody should administratively find out why did you call it a voluntary statement. Now, voluntary statement is very important because it is admissible. Unlike a statement given to police, the statement given to you people is admissible as evidence. Now, when it is admissible as evidence, there should be some purity in recording of the statement. If you say it is a voluntary statement, it should be really voluntary statement. It cannot be an involuntary statement given under coercion. Now, he can say anything he wants. You must have corroborative evidence if you confront him with it and you say that what you are saying is wrong. These are the invoices, these are the things, this is the email that I have got from you. It is very clear that what you are telling is a lie. And at that time, if he admits that yes, this is a lie, it requires huge amount of investigative ability, In fact, if you see Customs Act and all, the word investigation is not used, inquiry is used. It requires huge amount of talent to make this inquiry. But we don't want that. It takes huge amount of time and huge amount of effort. So what do? We do shortcuts. We say, we called him, he gave a voluntary statement, he admitted. What did he admit? He admitted that he has done all these things. Since he has admitted, everything is confirmed. Then why such a case gets thrown out at higher judicial forums? Once he has admitted, once everything you have done is pure, once whatever you have done is correct, and there is so much of admission, then what is it that makes that drop at a higher level? This is what is required to be understood. If you are simple and correct and clean right from the beginning and only raise demand which is for which you have real evidence, for which even though it may be little less, but it will surely stand. Many of the cases where the show cause notices is very well drafted, the demands are correct, 99% the taxpayer goes for settlement. He goes to settlement commission and he tries to come out clean and say that this is what I have done and let me get out of this whole process. But if you create demands which are fictitious, which are not supported by evidence, which are not supported by any corroboration, then it becomes easier for them to defend it at a higher stage. Reason being, there they are heard. Now that brings us to the next point of this demystification business, natural justice. You have to understand that it is not justice, it is natural justice. Meaning, even in nature, as we are humans, or probably even in animals, there will be a code of justice. There will be a code of justice that somebody should be heard before you punish him. Now, process of adjudication, the element of adherence to natural justice is one of the most important elements. Most important. The first thing which I told was on the basis of authority. If you are going to enforce your authority just because you hold that position and you have that statute, the empowerment through that statute, then you are going to miss natural justice. Whereas in adjudication, if you want it to be demystified, then please understand that natural justice is absolutely the cornerstone of adjudication. And what is natural? Why do we call it as natural justice? Why don't we call it as by any other name? The concept of natural justice is prevalent in all areas of jurisprudence, whether it is tax or whether it is civil, criminal, here, there, everywhere, wherever. And it is there in our day-to-day life also. Anywhere, even if two children fight, and if you take the side of one child, the other will say, "You have not even heard me. You don't even tell what I want to say. You have not even heard." Natural justice. Now, if that is the case with small children who are not exposed to the intricacies of any law or legalities, this is a highly complex legal environment which we are talking of. Taxation, where money is involved. Nobody wants to pay tax. Huh? Given a choice, nobody wants to pay anything. It is human tendency. But we have to enforce it. But while enforcing, we have to ensure that they are made to pay only that much, as much is to be recovered from them, as much they are liable. Now, that is why Kautilya says that you must be like a honeybee, which is taking out the honey without destroying the flower. Now, if you destroy the flower, then it is. But many times you might have heard stories of entire businesses being ruined or entire businesses being hampered because of tax authorities, because of either the harassment or over enthusiasm or intervention of tax authorities. Now, this is not good. I mean, I'll give you one very strange example. Do you know that this Winston Churchill used to smoke cigar, and this cigar used to be made in Trichinopoli, Trichy. Even now, that family which makes that cigar is there. Having found out that, I went there personally. I went and to see how they are making, what has happened to it. And he didn't know I am from this department. After talking to them for 15-20 minutes, he said, "Sir, in the department, the Central Excise Department, tobacco, big ITC company and all can survive, but we cannot. But we are treated at par with, since we are dealing with tobacco, the whole outlook is very harsh on us." Now, just imagine if suppose this factor had been publicized, it had been embraced by the government or whoever, and takes up the issue that Winston Churchill used to smoke a cigar from Trichinopoli. And if you have read Sherlock Holmes, the very first episode of Sherlock Holmes mentions tobacco from Trichinopoli cigar. Very first episode. So there was a brand name for that. I don't know how far he's right in saying that our department was instrumental in his problems, but we could not build that brand. We could not make it big. We could not make it world famous. Which there was a potential, there is a possibility. Now, the thing is, somewhere we have not done what we should have done in terms of giving them the support, in terms of giving them the natural justice. That is where I was. Natural justice, inalienable part of or parcel of process of adjudication.